Welcome back. I am attorney Nicholas Hicks, and this is New York Child Support Part 2. Now, the law that we're going to discuss applies to New York State only. It is not intended to be legal advice. This is for informational purposes only. Please consult with an attorney in New York to discuss how the law applies to your particular circumstances. Again, welcome back. Now, the last time we left off, we were discussing child support and establishing paternity as a first step before we could talk about the child support obligation. We learned that both parents are chargeable with the support of children less than 21 years of age. Now we're going to talk about the actual child support obligation itself, how it's calculated, etc. Now, to begin with, when we determine what child support should be paid, we first look at the combined parental income, mom's income plus dad's income, to determine the entire parental income. And to begin with, there is a presumption that the residential parent, where the children reside, that parent is supporting the children because the children reside with that parent. And so in most instances, it is the non-residential parent that is paying support to the residential parent. And how is that amount determined? We use something called the Child Support Standards Act that sets out specific percentages that must be paid based on the number of children. So, for example, one child requires 17% of gross income after the deduction of FICA. 2 children, 25%. 3 children, 29%. 4 children, 31%. 5 children or more, not less than 35% of gross income after the deduction of FICA. Okay. Now, in addition to that basic child support obligation, there is something that we call add-ons, support add-ons. So, for example, unreimbursed medical expenses, unreimbursed child care expenses can be added to that percentage of that basic child support obligation. So here's a typical situation. Mom is the residential parent. She pays for medical coverage. Her employer deducts money from her paycheck per pay period to cover the family medical coverage, which covers the children. Well, dad can be required to reimburse mom some portion of that expense that she incurs to cover the medical expenses of their children. In addition, other out-of-pocket medical expenses like doctor co-pays, well visits, braces, and other kinds of uninsured medical expenses, dad can be required to share in that on top of the basic support obligation. In addition, child care. Mom works. The children are too young to stay at home by themselves. They have to go to after-school care, or they're too young to go to school and they're in daycare all day. This is pretty expensive in most instances. And again, dad, in this example, will be required to pay a portion of that daycare or after-school care, again, on top of that basic child support obligation. So, now, let's take a look at circumstances that could change the application, the strict application of the Child Support Standards Act, those percentages, 17, 25, 29, etc. On the lower end of the income scale, we have something called the self-support reserve. The self-support reserve is based on what the current national poverty line number is. Every year that changes. I don't have the exact number, but let's suppose that the self-support reserve and the poverty line is $12,000 a year. I believe it's higher, but 12,000. And suppose that if the court applied the percentage to dad's income, once that was subtracted from his income, that would take his income below the self-support reserve or the poverty line. Dad could ask the court to not take that percentage, but take some lower amount or lower percentage because that is placing him below the poverty line. And if the court deems that appropriate, it can do so. So that's one vehicle to deal with the lower end of the income scale when applying the child support percentages. Now, on the higher end of the parental income spectrum, suppose that mom makes $100,000 a year and dad makes $100,000 a year. So combined, they make $200,000 a year. Mom is the residential parent. Dad would be paying mom as the non-residential parent. And I don't have the FICA calculations, but we apply the 17%. They have one child, let's say. Dad would pay approximately $17,000 a year to mom because his portion of the parental income is $100,000. And he says to the court, look, the child doesn't need $17,000 a year to be taken care of. In that instance, the dad could say or ask the court to please impose what's known as the child support cap. And the cap is an artificial sort of ceiling that would artificially lower what the parental income is. So that amount has changed a few times over the years. Currently in New York State, the child support cap is $141,000. So if the court agreed that the child did not need $17,000 based on dad's $100,000 a year earnings, it could lower the parental cap from the actual amount of $200,000 in our example to $141,000, then determine dad's portion of the $141,000 is 50%, just as it was in the $200,000 situation, and then apply the 17% to half of the $141,000, which would artificially lower his support obligation in this circumstance. So that's something that a court can do, and in some circumstances will do, depending on the individual circumstances. And again, it's a case-by-case basis. So on the lower end of the income spectrum, you have what's known as the self-support reserve. On the higher end of it, you have what's known as the child support cap. Okay. Now, we've talked for a few minutes about how child support can be calculated, the sort of the safety valves at the bottom and at the top. Let's talk a few minutes about what is not child support, because this is important. I've seen people get in trouble over the years about this. So here's a typical situation. Mom and dad, there's a child support order that says, Dad, pay mom $100 a week for child support. And he's doing that for a while. Mom and dad get into an argument. Dad says, Mom, you aren't using, I don't like how you're using my child support. You're not buying what my kid needs, or you're spreading that out to your other children who are not my children, or whatever the circumstances are. I'm not going to give you any more money directly. I'm just going to buy my kid what my kid needs directly. And so I'm going to buy his school clothes, or I'm going to buy his school supplies. Well, here's the problem. She could take him back to court on a violation of child support, and although he has spent $100,000 a week on the child, he has accumulated child support arrears because he's disobeying the order by not paying mom the money directly. So you have to be very careful with that. If there's a dispute about how money is being spent, or you believe that there's something that the residential parent is not doing, that's something you might want to litigate in court. You have to ask a court to modify that support order. You can't unilaterally change the terms of that support order. If you do so, you do so at your own peril. You have to go back to court to ask the court to modify that support order. You can't do that yourself. Now, on the other end of that, there's something known as imputing income. You can't walk away from a job and just quit a job for whatever reason, and now you've lowered your income or you have no income. The court says that our children deserve the benefit of our incomes. So again, you have to be very careful about how your how your job terminates. If you walk away from a job voluntarily, or you lose your job because of some wrongdoing, the court can impute income to you and hold you at that support level, although you no longer have that income. We'll talk more about that next time. So when we come back, we're going to talk about more about imputed income. We're going to talk about how to change or modify a support order, and we're going to talk about what events terminates the support obligation. Okay, so stay tuned. I'm attorney Nicholas Hicks. Thank you for joining me, and I will talk to you soon. Take care.